After almost a decade of legal wrangling, a lawsuit against USVI rum manufacturers Cruzan and Diageo over what is referred to as rum fungus has been settled. It was 2013 when complaints from residents in the vicinity of the company's distilleries and warehouses on St. Croix started to arise. Black soot-like fungus was growing on surfaces in the residents' homes, on trees and plants in their gardens, and in their water cisterns. The fungus of genus Bowdonia is associated with concentrations of ethanol in the air. It feeds on the ethanol and proliferates on surfaces in the vicinity, whether metal, concrete, or organic matter. The rum manufacturers were quickly identified as the source of the problem. Bowdonia is known to flourish near distillation facilities and warehouses where the produced and stored alcohol evaporates into the air, providing ideal conditions for fungal growth. In 2014, residents filed a class action lawsuit against the two companies, which in 2018 was split into individual complaints on the order of the presiding judge. All 120 cases in the mass tort established claims of negligent trespass due to the invasion of the company's ethanol emissions onto the plaintiff's property, intentional trespass because the companies reportedly knew that their emissions were causing the growth of the black fungus on residents' properties, negligence because the companies failed to implement established mitigation measures to capture and eliminate ethanol emissions at the point of generation, and private nuisance for preventing the plaintiffs from using and enjoying their property due to the encroachment of ethanol emissions and the resulting fungal proliferation. In response to the lawsuits, both Cruzan and Diageo initially denied the allegations against them. But the alarm raised by the plaintiffs caught the attention of the government, namely the Department of Planning and Natural Resources and the legislature itself. At a June 2015 hearing of the Committee on Health, Hospitals and Human Services in the Senate, both DPNR and lawmakers said that they were mulling over enforcement actions against the rum manufacturers to deal with the problem. But that action did not ultimately materialize, as in 2016, Diageo's aging warehouse was closed by the company, which largely eliminated the rum fungus problem, according to attorney for the plaintiffs, Vincent Coliani II. As December 2022 drew to a close, news began to circulate that a settlement had been reached between the rum manufacturers and the plaintiffs. Consortium journalists spoke to Coliani, who confirmed that an agreement had indeed been reached.
Litigation, especially of this magnitude, is very expensive for both sides, and there are obviously risks on both sides in going to trial. So I think both sides came to the conclusion that it was in their best interest to resolve this rather than go through a trial process that could result in a very uncertain outcome. So it gives both sides certainty, and it gives the plaintiffs a sum of money and eliminates the risk that going to trial, that if they went to trial they would receive nothing or less, and it gives defendants the peace of mind of settling for some certain and not having to worry about an extremely large jury verdict that, again, is hard to predict. So both sides weigh the risks and benefits, and in this situation, as in most cases, the sides came together and decided, each decided it's in their best interest to settle this matter rather than to go forward through the trial process and the appeals and extend the litigation any further.
The settlement provides class status to affected parties, which Coliani explained meant that not only would the 120 property owners who filed suit be eligible for compensation, but all property owners in estates surrounding the Cruzan and Diageo facilities, including Estate Diamond, Williams Delight, Estate Kane, and Enfield Green, who purchased their homes prior to 2007. However, the plaintiffs in the lawsuits will receive additional funds from the settlement.
Both Diageo and Cruzan were of the opinion and made it a condition of the settlement that we convert the case to a settlement class and include all homeowners who were potentially affected by the rum fungus. And the reason for that is they didn't want to settle with the 120 persons or homeowners who we represented and then have someone come back in 6 months or 3 months or 8 months and sue them. So this by converting the case to a class action, anyone who was potentially affected by the rum fungus will have an opportunity to make a claim. Once that process is concluded and the class settlement is approved, no one can then come forward and sue Diageo or Cruzan for any rum fungus contamination. So it essentially gives them closure and buys them peace. And it was a condition of the settlement on their part, and something that we felt we needed to agree to settle the case, and something we thought was reasonable, again, in light of the circumstances. I will say our original 120 homeowners have been litigating this case for years. Many of them have been had their depositions taken. They've provided us with information. They've had their homes inspected, and those persons who were originally part of the lawsuit will receive an incentive payment in addition to what they would be entitled to as a class member. And that's, of course, only fair because they've been in this case for 9 years. They've contributed their time, energy, and resources to helping move the case forward. So those the original 120 plaintiffs will receive an incentive payment in addition to their share of the class sum.
Property owners adjudged to be eligible for settlement will next week, according to Koliani, begin to receive notices in the mail inviting them to join the settlement class. They will then have approximately 1 month to return those notices indicating that they will join the class. Ultimately, the sum of money paid out per person will depend on the total number of claims received, vetted, and accepted. On March 30th, 2023, a final hearing is scheduled to take place where a judge will rule on whether the agreed settlement is acceptable to the courts.